Hello, my name is Kirk McKenzie, the founder of Defend Rural America. Today I'm talking about advanced topics of jurisdiction, and it requires that you have watched the prior versions first in order to fully understand what we'll be talking about today. In prior training, we talked about the authority that states and counties have, with the learning that they have far more authority and jurisdiction than they believe or have been told. The question then is, what authority does the federal government have? A topic we will now discuss. 3 years ago, in a Citizen Newswire email that I sent out, I posed the question, what is the United States? And I made the following comment. This and other information you are being exposed to for the first time may sound crazy. I know, been there, done that. However, 20 years of research led me to conclude nothing is as it seems. For your own sake, this is the time, if there ever was one, to open up to new ideas. If you're not ready to accept new information, at least don't toss it off simply because it doesn't fit with your current understanding of the world. Be a juror, not a judge. Let the information in and hold off judgment until more information comes in, then decide. I concluded with this quote. The individual is handicapped by coming face to face with a conspiracy so monstrous he simply cannot believe it exists. The American mind has not come to a realization of the evil which has been introduced into our midst. It rejects even the assumption that human creatures could espouse a philosophy which must ultimately destroy all that is good and decent. Now, this isn't just any person making the statement. This is J. Edgar Hoover, the nation's first FBI director, a position he held for more than 25 years. Somebody who knows what he's talking about. He made this statement in 1956. What then is the United States? Here's our view of the United States, and I will call this the de jure United States. It comes from the French. De jure means of law. In other words, lawful or constitutional United States. In the United States, sovereignty resides in the people. In 1828, Webster Dictionary did not include a definition for the United States. Apparently, it was deemed unnecessary. One and only one well-understood definition existed. This map shows the territories that eventually became states. And these are the dates of the treaties. They range from 1803 with the Louisiana Purchase to the last one in 1854 with the Gadsden Purchase. Interestingly, it's not until after the Civil War, and specifically the Spanish-American War of 1898 and 1899, that further land acquisitions are considered to be exclusively territories or possessions of the federal government. The key date I want you to remember here is 1854, the last treaty. Because 2 years later, Bouvier's Law Dictionary has this definition for United States, the name of this country. Something that we could understand. The United States, now 31 in number, are, not is, are. The definition of the United States in effect at the time that the territories came into existence was an understanding that the United States was a collection or a union of multiple nation states, which are listed here. Besides the states which are above enumerated, there are various territories which are species of dependencies of the United States. In other words, of all of the United States, of the Federation, of the country, not of the federal zone. The states individually retain all the powers which they possessed at the formation of the Constitution and which have not been given to Congress. Previously, we discussed the fact that the Congress wears two hats, passing exclusive legislative laws that cover the federal zone and general laws which are generally applicable to the entire United States. Laws passed by a government which control the operation of which it has jurisdiction are called municipal laws, as versus international laws that govern the relationships between nations. I'll use the word general law to refer to those laws passed by Congress that apply generally to all of the states. Under our understanding, the Constitution is the supreme law of the land, and therefore both municipal law and general law are bound by constitutional constraints. Now I'm going to talk about a change in this whole perspective. I'll call the three United States. In 1945, during the FDR administration, we have this remarkable Supreme Court decision, Hooven and Allison Company versus Evett. The term United States may be used in any one of several senses. It may be the collective name of the states which are united by and under the Constitution. In other words, the de jure United States, the definition that we would understand. But they go on. It may be merely the name of a sovereign, occupying the position analogous to that of other sovereigns in the family of nations. In other words, the federal zone is its own sovereign nation, operating in a family of other nations, in other words, the other states. And furthermore, it may designate the territory over which the sovereignty of the United States extends. In other words, the federal zone. We now have then three distinctly different definitions for the word United States. This triplicity of definitions exists in Black Law Dictionary, 4th edition, which came out in 1951, as shown here, was included in the 5th edition, the 6th edition, but by the time the 7th edition came around in 1999, that definition had been removed. No one would know at this point in time, looking at Black's Law Dictionary, that there are multiple meanings for the word United States. Is this an intentional deception? I believe so. Let's talk about the constitutionality implications. Returning to the Hooven decision, again it says, it is no longer doubted that the United States may acquire territory by conquest or by treaty, and may govern it through the exercise of the power of Congress conferred by 3 of Article 4 of the Constitution. And again goes on to make this remarkable statement. In exercising this power, Congress is not subject to the same constitutional limitations as when it is legislating for the United States. In other words, within the federal zone, it's constitutional for municipal law to be unconstitutional. And in general, the guarantees of the Constitution extend to them only as Congress has made those guarantees applicable. It is an axiom of international law when you conquer a nation that the laws that were in effect in the Constitution continue in effect, but they will be changed automatically with new legislation passed by now the defeated country. Are we then interpreting or using that same logic here, that the Constitution within the federal zone applied, but is now being changed simply by congressional legislation and not subject to ratification of the people? Therefore, we have two distinctly different views. Ours, which the Constitution is supreme, and theirs, in which they believe that their municipal law is completely unconstrained. They're using the exclusive legislation statement as the escape clause, saying that the Constitution that we generated for governing the federal government does not apply to the federal government in the federal zone. Public law theory is the theory that there are at least two different branches of law, one called administrative, which falls outside the Constitution, and general law, which falls within the constitutional framework. Now, many people, including myself, have looked at some of the Supreme Court decisions, executive decisions, and so forth, and realized on their face that they're unconstitutional. The question then is, are they just blatantly doing this, or has there been some kind of a legal framework fabricated, however fraudulent, to somehow justify their actions? Different people have come to different conclusions. Some have concluded they're operating in an administrative law, admiralty law, merchant law, UCC code, martial law, and others. My conclusion is they're all right. Everyone is right, because it's unconstrained and can take on any characteristic that it wants. And what then, how are we to interpret the law? And this is where I believe the deception gets even worse. We have but one Congress, but it's passing two very different kinds of laws, one after the other. They go into the same Federal Register, the same U.S. Code, the same Code of Federal Regulations. They're decided by the same courts and judges. And we don't even realize there's a difference between the laws of the United States or United States law. They all appear to us to be one and the same thing. We therefore incorrectly interpret municipal laws as applying to everybody and everywhere. The restoration relies on our ability to separate out those laws that have a very constrained interpretation or application versus those that are general in nature. Is it true it can be constitutional or be unconstitutional? You decide. Where the meaning of the Constitution is clear and unambiguous, there can be no resort to construction, in other words, reinterpretation of the meaning of words, to attribute to the founders a purpose or intent not manifest in its letter. The courts cannot rightly prefer of the possible meanings of the words of the Constitution that which will defeat rather than effectuate the constitutional purpose. If the legislature clearly misinterprets a constitutional provision, the frequent repetition of the wrong will not create a right. It is a peculiar value of a written Constitution that it places in unchanging form limitations upon the legislation and thus gives a permanence and stability to popular government which otherwise would be lacking. The Constitution is an instrument from the people, and a construction therefore should effectuate their purpose for the words employed in the document. And the courts may not color it by the addition of words or the engrafting of their views as to how it should be written. What are the implications of the three United States as we interpret it to mean on land? Returning to the Hooven decision, we see that the United States word appears 3 times in this quote that I've given, so interpretation is critical. How do we interpret all 3 instances mean the same thing, or that 2 different meanings are at play here, or 3? We'll start with this one. In exercising this power, Congress is not subject to the same constitutional limitations as when it is legislating for the United States. From this wording, it's clear that this United States refers to the sovereign United States. But how about these 2 references? The United States may acquire territory by conquest or by treaty. And then it goes on to say territory or other property belonging to the United States. Are we to therefore conclude that that territory, it belongs to the people of the United States, to the United States as a collective, as a whole, as 50 different states? Or do we believe that that means that that belongs to the federal zone? What are the implications on sovereignty? Returning to the Prince decision, we find the following. The federal government may neither issue directives requiring the states to address particular problems nor command the state officers. But it then goes on to say, such commands are fundamentally incompatible with our constitutional system of dual sovereignty. Dual sovereignty? Where does that come from? The people are the sovereigns and the only sovereigns. What is this dual sovereignty? What we're now discovering is that the federal zone, not only has the decision been made that municipal law is unconstrained, but that the federal zone is actually a sovereign country unto its own right. And it is on an equal with the other family of nations, in other words, with the other 50 states. Which brings us back to a question posed in an earlier training session. What's the full name of the Constitution? Constitution for the United States, meaning a constitution of the people for the government that they had created. Why do we now call it the Constitution of the United States? Is it because it is basically the Constitution of the federal government for itself, and therefore subject only to legislative amendment? And what about this? What about the use of the fringe on the flag? Does that then refer to the federal zone and the federal nation? And that without the fringe, we're referring to the general or the constitutional de jure United States? And what are the implications on citizenship? The first clause of the 14th Amendment made Negro citizens of the United States and citizens of the state in which they reside, and thereby created two classes of citizens, one of the United States and the other of the state. It is quite clear then that there is citizenship of the United States and a citizenship of a state, which are distinct from each other. We have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from the others, and each has citizens of its own. Now, the 14th Amendment is a very important amendment because of the way it has been interpreted. The interpretation of this amendment has changed everything. It's created a federal country. It's created persons with rights that are not actually human beings. Legal fictions like corporations are now on a par with people in terms of being able to own land, to be able to make financial contributions to elections and so forth. It's extended the federal zone not only to have control over land, but also control over people. And it was not ratified, as we will now discuss. So now we go to the language of the 14th Amendment. We discover that these debts become locked in. Now the 13th Amendment we'll come back to was the one that freed the slaves. The 14th Amendment actually creates a citizenship, a federal citizenship. Up to now, the people of the United States were actually citizens of their sovereign states. The federal government was just an organizing body. It was not a country, so to speak. And yet, with the 14th Amendment, it declares that it is kind of a country and that it can have a federal citizenship, a second classification of citizenship, which belongs to that 10 square mile area known as the District of Columbia. It imposed due process on the states. Interestingly, it was the opinion of the Supreme Court, going back to Marshall, that the Bill of Rights was not the supreme law of the land, that in fact it only applied to the federal government and did not impose those obligations on the states. By this it says, nor shall any state deprive any person of life, liberty, or property without due process of law. And so the Supreme Court decides that those powers, the Bill of Rights, are not the supreme law of the land, but now they are going to incorporate as supreme law of the land those that pertain to due process law, and only those. If we read Black's Law Dictionary, 7th edition, on the word incorporation, it says the process of applying the provisions of the Bill of Rights to the states by interpreting the 14th Amendment's due process clause as encompassing these provisions. In a variety of opinions since 1997, the Supreme Court has incorporated all of the Bill of Rights except the following: the Second Amendment right to bear arms, the Third Amendment prohibition of quartering soldiers, the Fifth Amendment right to grand jury indictment, the Seventh Amendment right to a jury trial in a civil case, and the Eighth Amendment prohibition of excessive bail and fines. I understand what this is saying. All of these things are not guaranteed. They're at the whim of the state. Now, this was debated. The idea of selective corporation is the idea that the 14th Amendment only incorporated certain things, those pertaining to due process, not these other things. That view, which prevailed, was held by Justice Benjamin Cardozo, who served from 1932 to 1938. Opposing him, who failed and lost the battle, was Justice Hugo Black, who believed in total incorporation, that in fact the Bill of Rights was the supreme law of the land in all of its provisions. We also see in here Section 4. The validity of the public debt of the United States shall not be questioned. Now recall that the public debt just increased by a factor of 43 times. Does this provision then put the newly created debt beyond any judicial review? Apparently that was its purpose. Is this true today? And then finally, Section 5. The Congress shall have power to enforce by appropriate legislation the provisions of this article. Well, what does that mean? because the 14th Amendment creates this thing called a federal citizenship. Is this then saying that that federal citizenship is not controlled by the Constitution of the United States, but rather by Congress's legislation? Apparently that's what it's interpreted to be. Your federal citizenship is not covered by a constitution. And in fact, in 1871, the first Civil Rights Act was passed. So how did this amendment actually get passed? April 9, 1865, General Lee surrendered. Within a week, President Abraham Lincoln was assassinated. And the Vice President Andrew Johnson took over. And on April 2nd, he declared the insurrection over. The southern states were subsequently restored and reseated in Congress. Now, the 13th Amendment, which eliminated slavery, was approved by Congress on January 31st, 1865. The southern states participated in the ratification process, and in fact, 7 southern states voted in favor of this amendment. It would not have been ratified otherwise. And on December 18, 1865, Secretary of State William Seward declares the 13th Amendment is ratified. The 14th Amendment is a different matter. It's approved by Congress on June 13, 1866. 3 days later, the Congress sends it to the state for ratification. On June 22nd, President Andrew Johnson makes it known that he was completely bypassed in the process. He had not been consulted, nor had it been given to him for his approval. 15 states rejected the 14th Amendment, Texas being the first, October 17, 1866, followed by 14 others within short order. The 14th Amendment could not be ratified in this situation. So what was the response? In this list includes 7 of those, the 7 that had in fact voted in favor of the 13th Amendment to abolish slavery, were now voting against the 14th Amendment. The Radical Congress, consisting of radical Republicans, respond by passing 4 acts called the Reconstruction Acts. In effect, what these do is they put 10 states under military rule, including the 7 that had ratified the 13th Amendment but were now choosing to vote against the 14th Amendment. The states were denied representation in Congress. Their legislatures were removed with military force and replaced by rump legislatures. And under military threat, they were forced to change their constitutions, elect suitable legislatures, and ratify the 14th Amendment. This ratification passes over President Andrew Johnson's veto. He says, Congress declares these local states to be illegal governments and then provides that these illegal governments shall be carried on by federal officers. How can that be, he says, and points out the illogic of the situation. When 7 of which votes were given in favor of the 13th Amendment by 7 of these states, in other words, when these 7 southern states voted for the 13th, we accepted them, and we accepted them as valid votes. It was proclaimed to be a part of the Constitution, and slavery was declared no longer to exist. If these 7 states were not legal states of the Union, it follows and is an inevitable consequence that in some of the states slavery yet exists. In other words, how can you possibly argue that these states could have ratified the 13th, but if they choose not to ratify the 14th, that they don't have that choice? They don't have free will in that regard. Within a period less than a year, the legislation of Congress had attempted to strip the executive department, in other words, the president of the government, of some of its essential powers. The military commander is, as to the power of appointment, made to take the place of its president. And the general of the army, the place of the Senate. And any attempt on the part of the president to assert his own constitutional power may, under pretense of law, be met by official insubordination. Congress passes Reconstruction Acts, puts the 10 states under military rule, declares that the process is okay, and then on July 20th, 1868, Secretary of State William Seward expresses doubt that there has been proper ratification of the 14th Amendment. The very next day, the Radical Congress declares, well, we think it's been ratified, and passes legislation to that effect. And a week later, then, William Seward says, well, if Congress has passed legislation saying it's passed, ratified, then I guess it has been. Such is the condition under which the 14th Amendment is allegedly ratified, and makes such fundamental changes to our country. Citizenship is governed by municipal law. That is its very nature. Therefore, federal citizens have no constitutional protections or inalienable rights, only civil rights, privileges granted at the whim of government. Negroes were not freed. They simply went from being chattel property to being property of the federal nation. In 1868, Negroes were brought in as taxpayers directly to the federal government and received their civil rights in exchange in 1871. All the people in the U.S. possessions became taxpayers directly to the federal government with the 1898-1899 treaties. With the alleged passage of the 16th Amendment in 1913, allegedly all Americans now became payers into the federal government, and the 1935 Social Security Act, as we shall discuss. Very soon, every American will be required to register their biological property in a national system designed to keep track of the people, and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Every American will be forced to register or suffer being unable to work and earn a living. They will be our chattel, and we will hold the security interest over them forever by operation of law merchant under the scheme of secured transactions. Americans, by unknowingly or unwittingly delivering the bills of lading to us, will be rendered bankrupt and insolvent, forever to remain economic slaves through taxation secured by their pledges. They will be stripped of their rights and given a commercial value designed to make us a profit, then they will be none the wiser. For not one man in a million could ever figure our plans, and if by accident one or two should figure it out, we have in our arsenal plausible deniability. After all, this is the only logical way to fund government, by floating liens and debt to the registrants in the form of benefits and privileges. This will inevitably reap to us huge profits beyond our wildest expectations and leave every American a contributor to this fraud, which we will call social insurance. Without realizing it, every American will insure us for any loss we may incur, and in this manner, every American will unknowingly be our servant, however begrudgingly. The people will become helpless and without any hope for their redemption, and we will employ the high office of the president of our dummy corporation to foment this plot against America. This is a quote by Edward Mandell House, who liked to call himself a colonel even though he hadn't earned that position. He was President Wilson's handler and the closest of advisors to Franklin Delano Roosevelt. What then is their view of the United States? In their view, it's a country. It is therefore a foreign country. It's foreign to the Constitution, and it's foreign to the 50 states. In the same way that a corporation formed in California is domestic from the perspective of California, but foreign from the perspective of Montana or Utah or Nevada, because those are actually different nations. What is it in fact? It's a renegade government. It is both occupied and hostile. In summary, the states and counties have far more authority and jurisdiction than they believe. They have legislative authority over the public lands. The ownership belongs to the people. And the trustee is the de jure or constitutional federal government. The federal government has far less power than we have been taught. It does not have ownership, but even if you believe it does, ownership does not bestow legislative authority. General legislation must be constitutional. Municipal legislation, in their view, does not have to be abiding by the Constitution, but then it's only applicable within the very narrowly constrained federal zone. In my view, there's been a revolution. The expansion of this federal zone to include land through misinterpretation of Article 1, Section 8, Clause 17, and Article 4, Section 3 of the Constitution, an expansive definition of the word commerce, and recently neo-environmentalism. It's also now grabbing people, either under the 14th Amendment citizenship or under the view that even if they aren't American citizens, if they live in the federal zone, they're under the federal jurisdiction, or if they derive benefits from the federal zone, such as Social Security. And furthermore, it's taking over local and state government, both through the ignorance of the people and our representatives, through a process of theft of taxes and then bribery. If we are to restore our United States, it can only be accomplished at this point through state intercession, specifically the rural states. I hope this information has been useful to you and will be applied by appropriate legislators and county commissioners and supervisors to begin the restoration of a government based upon a sovereign people and a government by consent of the government. Thank you for your time.